at Samford University in Birmingham, Alabama, and I've come to the Searle Civil Justice Institute conference to deliver a paper on insurance regulation and insurance litigation about insurance company bad faith. This is something that's only about 50 years old. It began in California with a decision in 1957 and spread across the country. The bad faith litigation duplicates bad faith regulation by the states. And so my paper looks at that and asks the question, do you really need two different sets of rules about this, particularly if the litigation allows a plaintiff to recover tort damages. And by tort damages, we mean that the plaintiff can recover damages for mental anguish and also punitive damages in some cases. And although this doesn't happen very often, the punitive damages are not awarded in very many cases. It does happen, and it's a little bit on the unpredictable side. And so that's an aspect of the litigation that troubles some people. I've looked at the economic research on the effects of the litigation. And what I've found is that there seems to be a pretty good case that states, there are only about 25 states that have recognized a cause of action, a lawsuit for insurance bad faith. And in those states, insurance companies tend not to investigate claims that seem to offer some indication of fraud in the claim, and as a result pay out on claims that in states without this doctrine they would not. And so the result is that the cost of insurance goes up to people in those states for a benefit that they don't get. And so my suggestion in the paper is that we could probably do just as well with sticking with the regulatory side of things and allowing the state insurance departments to handle this question rather than giving individual insureds the ability to sue their company for alleged bad faith. The one exception to this might be the original version of these lawsuits, which was about insurance companies' refusal to settle cases at amounts that are within the policy coverage limits. And I think the evidence is not as strong in those cases as it is with regard to the cases where the insured is claiming that the company unfairly or unjustly denied the insured a benefit under the policy.